Welcome to DRTSPR show. This is Dr. Tangella Shiva Prasad Reddy alias Dr. TSPR. Namaste, Adab. Hello and a warm welcome to Ravichandran Swaminathan ji. Sir, namaskaram, vanakkam.
Namaskaram.
What you predicted few months ago is coming true again. How dangerous electoral bonds will be for the democracy to prevail in India, to survive or sustain in India. It has once again become true, and Supreme Court, though it took some time since 2015, we were challenging, we were discussing, we were trying to request, demand Supreme Court. Ultimately, since 2015, the matter which was being heard, 15th February 2024, that is why DRTSPR channel stated Democracy Day. It has struck down electoral bonds and stated it is anti-constitutional. Very clearly, without any information to voter like us, to citizen who is a constitutional authority, those funds who are funding very obscure, and as our Ravichandran ji has done in ISRO's case, he has given me a flyer or poster. Nothing is visible. Can it be that way? So this show, we are expanding on the good decision, the good order of the Supreme Court to conduct elections in a free and fair way. And I'll just show you just a minute only, not more, because such a good show today it will be. Ravichandran Swaminathan ji, this is the thing which is going to share today. And before that, I'll just give you electoral bonds worth over 16,000 crores sold so far. Who got what? The Supreme Court annulled the electoral bonds. I need not again reiterate. Just quickly running through the right to privacy of political affiliation does not extend to contributions made to influence public policy and applies only to contributions below the threshold. Chief Justice of India, D.O. Chandrachud. Information about funding of political parties is essential for electoral choices. CGI. We are trying to give you in a different way. And immediately after that, the Congress is complaining. Let us listen to him.
और बेड़ियां हैं और यूथ कांग्रेस और कांग्रेस दोनों के अकाउंट्स जो फ्रीज करे गए हैं 210 करोड़ की रिकवरी इनकम टैक्स डिपार्टमेंट ने यूथ कांग्रेस और कांग्रेस से मांगी और ये पैसा किसका है? ये कोई धनाढ्य पूंजीपतियों का पैसा, कॉर्पोरेट टैक्स का पैसा नहीं, कॉर्पोरेट बॉन्ड्स का पैसा नहीं है। ये पैसा जो कांग्रेस पार्टी के अकाउंट्स में है वो ऑनलाइन जो हम लोगों ने क्राउड फंडिंग जो करा है उसका पैसा पड़ा हुआ है। एक कारण कि हम लोगों को 31 दिसंबर 2019 तक अपने हम लोगों को अकाउंट सबमिट करने थे और शायद 40-45 दिन लेट अकाउंट सबमिट उस वक्त किया। इनकम टैक्स के ऊपर हम सबके सब लोग 10-15 दिन अक्सर बहुत लोग लेट हो जाते हैं। उसके बेसिस के ऊपर एक कारण ये, और दूसरा कारण क्या है? सिर्फ 14,40,000 रुपया हमारे कांग्रेस के एमपीज और एमएलए ने एक महीने की अपनी तनख्वाह कैश में जमा कराई थी, सिर्फ 14,40,000 रुपया। और 2018-19 का किया हुआ आज जाकर के 5 साल के बाद में चुनाव की घोषणा से 2 हफ्ते पहले हमारे अकाउंट्स इसको लेकर के फ्रीज कर दिए जाते हैं। चुनाव से 2 हफ्ता पहले अगर किसी भी पॉलिटिकल पार्टी के अकाउंट जब फ्रीज हो जाते हैं, उसके ऊपर तालाबंदी हो जाती है, तो ये लोकतंत्र के लिए इससे ज्यादा चिंता और दुख की बात नहीं हो सकती।
यस, लोकतंत्र के लिए कोई दुख की बात नहीं हो सकती। दिस इज वेरी बैड। इनकम टैक्स शुड ऑल्सो scan the accounts of BJP, all other political parties across India. And another issue, Congress party, why are you allowing money to rule the elections? You have been ruling India for such a long time. You missed a chance to reform income tax system, to reform electoral system. You missed a chance, Congress. Now you are ruining. The same will happen to BJP if it doesn't understand the purpose of. Supreme Court rejects Union government's argument that citizens have no right to know about political funding. And this is another one, same. So now I'll straight away come to Ravichandran Swaminathan's PPT. Yes, sir. It's on your screen.
Can you go to the first?
Yes, sir.
The electoral bond scheme we have already talked about these things. I think we have 40 minutes on this channel, isn't it?
Yes,
Dr.
sir.
Reddy?
Yep.
So I will skip through all the first three slides. I think can skip because we have already covered it in our earlier discussion.
Yeah. This is how the sample we have given: electoral bond, State Bank of India, only one bank which is under the control of government. And don't you think it is not free and fair? Government can do anything. If someone supports Congress, it will have an idea, information. Yeah.
The bonds were first issued in 2018 to enable anonymous donors to political parties. Number one. My basic objections, our basic objections to this was amendments to constitutional acts were made through finance bills. Actually, an amendment to a constitution act has to go through the Lok Sabha, has to go through the Rajya Sabha, and only then it can be considered as a constitutional amendment. But here, a finance bill which was passed by the Lok Sabha was used to amend the constitutional act itself, which was bad in law. And this has been upheld by the Supreme Court, as we have told earlier, that this can be declared ultra vires constitution. The first is the same. Second point was the bonds are promissory notes issued by State Bank of India. Now only Reserve Bank of India has got the right to issue promissory notes under the RBI Act. And this was amended in the electoral bond scheme, and State Bank of India and any other scheduled bank authorized by the central government could issue promissory notes, which was bad in law, and this has also been thrown out by the Supreme Court. Now, the money has to be paid through KYC verified accounts or by digital schemes. No comment was passed on that. Only parties that get 1% or greater votes will be able to access electoral bonds. Which means if you and I start a party tomorrow, or if you and I stand as an independent, we will not be eligible for this electoral bond scheme. Nobody can give us money through electoral bonds. This is patently unfair. This is patently undemocratic. And this was also thrown out by the Supreme Court. The bonds have to be redeemed by the parties within 15 days of issue through designated account. This particular section was brought in because of RBI's insistence. But of course, since the entire electoral bond scheme has been thrown out, this does not matter anymore. Can we go to the next slide?
Yeah.
Anonymity. Now, the bond does not carry the name of the donor or any other identifiable details. Only three people will know who the donor is. One is State Bank of India, the donor himself, and the party who receives the money. But it is not necessary that the party who receives the money should know the donor, because the fundamental idea of this electoral bond scheme was to prevent black money from entering into these electoral funding, election funding. But in practice, what has happened is, once the promissory note is issued by State Bank of India, for example, let us assume that I purchase a 1 lakh rupee promissory note from State Bank of India. All that I have to do is sell it to Dr. Reddy for 1,10,000 rupees cash. Now, Dr. Reddy can take this promissory note and hand it over to a party of his liking and tell them, you take it into the electoral bond scheme. Or in other words, I have given Dr. Reddy a chance to convert any black money that he has got into white.
That's it.
That's it. It's as simple as that. So it does not serve its purpose of preventing black money from entering the funding system. Second thing, the bond does not carry any serial number or identifying details.
Yeah.
Or in other words, I can also print a promissory note.
Anyone can.
Anyone can do it.
Duplication.
Duplication. Political parties need not disclose the details of the funding. For your information, 93% of the funds received through the electoral, 93% of the total funds received by every party has come through the electoral bond scheme and it has been declared from unknown sources.
Now you see.
Now,
Money
where is the
regularized.
question of transparency in this?
Black
Now,
money
I don't know
regularized.
whether.
Modi and Amit Shah were shouting BJP. Now you have regularized black money directly.
Now, I don't know whether this money has come from China. I don't know whether this money has come from Adani or Ambani or from some BJP member who has got excess money in cash. So the fundamental position of the government saying that it is to avoid black money from entering has been destroyed completely. RBI has also flagged this situation. They have said that now there are three things here. When this bond scheme came, it amended the People's Representative of People's Act. It amended the Companies Act. It amended the taxation laws also. And in all the three, in the Companies Act, there was a restriction of 7.5% earlier. 7.5% of the total profits generated over the last 3 years. That was the maximum amount that could be given to a party as a contribution. Number one. Number two, this act amended the Companies Act by removing the limit of what money can be given. Now it is not required that a company should have profit or it can make loss also and still contribute unlimited money to the party in concern. Or in other words, I can float a shell company, declare a loss of 100 crores and show a contribution of 50 crores to XYZ party.
Absolute nonsense.
How is this acceptable? This is what Reserve Bank of India also said, that black money can be routed through shell companies to fund political parties, and there is no bar on that at all. Then the third thing was, these shell companies could be used for laundering money, which was actually what was happening. Now, illegal people can also do it. For example, narcotic dealer can use this process to fund parties. Terrorists can use this route to fund parties.
That is the danger.
Where is the end to it?
This is the danger,
what
Mr. This is the danger we were facing with Modi and Amit Shah. They don't read bills properly. Someone is chartered. Someone is Amit Shah और मोदी जी, हमको माफ करना, आप कुछ पढ़ते नहीं. जो भी लिख के देते हैं आप उसके ऊपर हस्ताक्षर करके पार्लियामेंट में लाते, हिंदुत्व के नाम पे आप बिल पास करवाते बिना समझे. कल के दिन आप जो बिल लाया इलेक्ट्रल बॉन्ड्स, ये पैसा कहां से आ रहा? टेररिस्ट से उसके पैसा है क्या? नारकोटिक्स ड्रग डीलर्स का पैसा है क्या? ब्लैक मनी शेल कंपनीज का पैसा है क्या? चाइना का पैसा है क्या? कैसा पता चलता? मोदी और अमित शाह जी, बीजेपी पार्टी, आप बताइए, आप किस तरह सोचे कि हम काला धन को खत्म करने के लिए इलेक्ट्रल बॉन्ड्स रहे? ये वैसा नहीं है. आप इलेक्ट्रल बॉन्ड के द्वारा पूरी काला मनी को यहाँ लीगलाइज कानूनी बनाया. आप बिना समझे बिना पढ़े जिस तरह हर एक बिल पे आप हस्ताक्षर कर रहे हैं, यही देश के लिए बहुत बहुत नुकसान होगा. मोदी और अमित शाह जी, आप जान जाइए. यस सर, प्लीज.
You go to the next slide.
And the same applies to Congress and other political
every
parties.
party.
You are not even
Every
discussing,
party.
debating what is happening tomorrow. If you may come to power tomorrow, another party may come to power. If they use all this to pump funds into political parties, will country survive? क्या देश बचेगा? कांग्रेस हो या टीएमसी हो, एएमआईएम हो? What is this nonsense going on?
Can you go to the next slide, please? These are the statistics. Out of the total money that was sold as electoral bonds between 2018 and 2022, till 23, BJP secured 58% of the total money. Now, the problem is the 7 other national parties, Congress, Trinamool Congress, National NCP, CPI, CPIM, and Meghalaya-based National People's Party. All of these parties received money through the electoral bonds. No parties have their hands clean on this.
Yes.
Every party has received money through electoral bonds. and they have accounted it as from unknown sources. For example, DMK, BJD and BRS alone account for 757 crores. Out of their total contribution, 96% is from unknown source or through the electoral bonds. These are some of the statistics which I got.
Local parties, family parties.
Family parties. Now, where did
running
this money come
Orissa,
from?
Tamil Nadu and erstwhile Telangana. Family parties, if they are owning so much of money, unaccounted money. आप सोचिए पैसा कहां से आ रहा पता ही नहीं चल रहा. ये कालाधन नहीं होता क्या मेरे देशवासियों? आप सोचिए किस तरह हमको गुमराह कर रहे, और वो भी एक फैमिली के पार्टी, जो कुटुंब पार्टी बोलते हैं हम. ऐसे पार्टी तमिलनाडु हो या तेलंगाना हो या ओडिशा में, ऐसे पार्टी को इतना पैसा कहां से आया कुछ पता ही नहीं, हमको जानकारी नहीं. और पूछे तो हम अगर समाचार जानने की कोशिश करें तो हमको कोई समाचार देने वाला नहीं है. ऐसे बिल मोदी और अमित शाह ने लाया है. कल के दिन मोदी अमित शाह के बाद ये दूसरे पार्टी कोई आया. देश की हालत क्या है और ये काला धन की क्या होगा हालत, पूरा देश को छा जाएगा. क्योंकि वो धन कहां से आया, टेररिस्ट से आया या ड्रग्स कंपनी से आया या चाइना से आया, क्या पता. ईस्ट इंडिया कंपनी जैसा ये पूरे मिलके देश को और एक बार गुलाम बनाने की बड़ी साजिश. ऐसे बिल बिना सोचे बिना समझे ये लोग पारित किया है. ये सब राजनीतिक दल इसको, ये जो सुप्रीम कोर्ट ने 15 फरवरी को जो कानून को खत्म कर दिया है, वो देश के लिए बहुत बहुत अच्छा है और चुनाव प्रक्रिया के लिए भी बहुत बहुत बेहतर है. सर प्लीज गो हेड.
Next slide, please. Now, there are some points of concern as far as this bill was concerned, as far as this was concerned. It amended the RBI Act, like I said earlier, contribution. Now, the main thing was contributions to political parties, disclosure of information and income tax exemptions. Can you go to the next slide, please? Now, amendments to the Taxation IT Act, political parties are not required to maintain a record of contribution received through electoral bonds.
This is
Which
nonsense.
They need not show the source of income. Then, amendment to election and other related laws, their political parties are not required to disclose details of contributions received under electoral bonds. Unknown sources. They can always put unknown sources. Now, RBI and ECI objected to these amendments. Unlimited corporate funding to political parties is violative of free and fair elections, because today a company like Reliance, a company like Adani Group, a company like can plow. We have seen this in the case of UPA also, where the Tata group of companies were actively involved through Neera Radia in appointing ministers in Manmohan Singh's cabinet. Now, if a corporate is making unlimited contribution to a party in power, they can dictate what policies are to be followed by the government and what sort of laws are to be made by the government in their favor. Or in other words, there is no question of free and fair elections, because remember, you have to secure 1% of the total national vote to be eligible for these funds, which means these funds can be allocated only to 10 or 12 national parties. Other people cannot access these funds. Then how is it a fair and level playing ground when you can access funds and I cannot access funds? And today, even for a MP seat, the election commission has decided as I think 75 lakhs to 1 crore, depending upon the constituency.
That is
That is the
ridiculous. How
maximum
can they
that can be
increase
spent.
the cap of the amount? How can they increase when per capita income has gone down in India? And how can I contest? I don't have money. That doesn't mean that I should not contest election. What is this nonsense? Where I can vote, but I cannot contest just because of this money.
Lack of money.
Money becoming major source for funding of elections, that too by corporates. They will control everything. Please, sir, go ahead.
Now, non-disclosure of information on contributions by political parties. This was mandated under the Election Commission, now Representative of People's Act and all that. But that has been amended. Now, there was a prayer in the Supreme Court saying that these are violative of the right to information of citizens under section 19(1)(a) of the Constitution. That is non-disclosure of information, because as a voter, unless I have information about what funds my party receives, how can I make a judgment on whom to vote for? So this is essential as prayed by one of the petitioners. Can you go to the next slide, please? Now, what is the judgment? The judgment says electoral bond scheme is ultra vires the constitution. It is unconstitutional. Then, second, unlimited funding by corporate houses is deleterious to democracy, which is correct, because they will dictate what policies the government has to follow. Now, the right to information of voters violated due to non-disclosure. Unless the voter is given full information about the parties, how can he decide on whom to vote for? So this is essential for good functioning of democracy. Now, the Supreme Court has also said that contributions, whatever contributions have been made so far, will be made public will be given by State Bank of India, because they know who has made the contributions, and State Bank of India will give it to the Election Commission of India, who will publish it on their website before 15th of March. Now, my concerns about this. The Supreme Court judgment is 5 years too late. This act came in being in 2018. Between 2018 to 2024, all parties have been collecting money through the electoral bond schemes. And there is a guarantee that the donor's identity will not be revealed. It is only under that guarantee that donors have given money to under the electoral bond scheme. Now, because of this judgment, where Supreme Court has asked State Bank of India to disclose all the details of the donors, what happens to the guarantee given by the Parliament to the donors that their identity will be kept secret? This is a breach of contract. The Supreme Court should not have used this, asked State Bank to disclose donations of all people. They should have restricted it to corporates, because in any case, corporates have to declare it in their balance sheets. And this is a big error which the Supreme Court has made, because it can be challenged in court. For example, I have made a donation of 1 lakh rupees to a particular XYZ party under the assumption that my identity will be kept a secret, because of the guarantee given by the Electoral Bond Scheme Act passed by Parliament. And today, after 5 years, if my identity is going to be revealed, then it is quite possible that I will be victimized by some party or some government or somebody. How is this fair to me? Under the Digital Personal Data Protection Act, my political affiliation is my right to privacy. Now this is being breached. The Supreme Court has not taken my consent to reveal my political affiliation, which I gave in confidence to the government, to the bank. If State Bank of India reveals my identity, then I can sue State Bank of India for under the Digital Personal Data Protection Act, because they have made public information which I consider to be my private information without my permission. How is Supreme Court going to circumvent this? That is why I said Supreme Court has come 5 years too late on this. This was a judgment which should have come in 2018 itself. Either they should have put a stay on the act and then pass the judgment, or they should have passed the judgment sitting then and there. 5 years is too long a period for all this. Second, as a citizen of this country, I have got a right to privacy. Now, in this judgment, Supreme Court has said that the right to informational privacy is subject to public interest. Or in other words, they have put a restriction on my right to privacy, which I consider as an inalienable right, a fundamental right which cannot be circumvented under any circumstances. Now, if Supreme Court says that my right to private informational privacy is subject to restrictions, then it automatically means that my right to privacy is also breached. And this is in violation of the constitutional guarantee to my right to live in dignity. This can be challenged in court again. That is why the Supreme Court has made a grievous error in clubbing. Actually, the judgment itself, the judges have distinguished between corporate donors and individual donors. But unfortunately, in their final order, they clubbed both of them together, and which was the biggest mistake. Corporate donors' identity can be revealed for two reasons. For number one is corporate donors, the amount is sanctioned by the board of directors and not all the shareholders, and the shareholders have got a right to know to whom the company is contributing. Yes. So in that case, a voluntary disclosure by the corporation is a must. Second, the corporate donors have already got to disclose it on their balance sheet, so it is in public domain. So, and the third thing is, corporates are not voters.
Yes.
They are not vote in an election. They are only artificial persons without a right to vote. Therefore, the level of privacy accorded to them is much lower than the level of privacy that is accorded to me as a private citizen. By making both of them together, the Supreme Court has made a mistake. And this is where my objections to this court order lies. It is a violation of my right to privacy by the Supreme Court, and where they have placed the right of informational privacy of a voter above my personal right to privacy, which is not acceptable. While the judgment per se holding the electoral bond scheme as against the constitution due to various reasons which has been cited by the Supreme Court is acceptable, the last, my right to privacy is breached, and this is not acceptable, and this is where I object to it strongly and strenuously.
Yes.
Two wrongs do not make a right. The government made a wrong, the Supreme Court has just compounded it.
But I only hope this should not be on democracy and free and fair elections. So, I think we can discuss.
We'll have to sum it up.
Yep. Can I stop the sharing?
Yes, yes, you can stop this.
Now, this is a very great and interesting arguments we have heard from Ravichandran and Swaminathan ji. I support it. Corporates, they have been looting because corporates are funded by banks, you have to make, and non-financial banking institutions. They go for, in common man's language, to make up for any losses or anything. They involve people's public money also through so many ways. They issue shares, they announce shares publicly, and people buy it. So for that reason, corporates can never escape the scrutiny of transparency and accountability if they are giving money to any party. And why not? Why don't you make it transparent and accountable? Why should you hide it? If I am liking some party, let me go and fund it. And even for individuals also, if I am funding, because I am asking for secrecy, is tomorrow I should not be victimized by another party if it comes to power. If I had supported and if I had given money, donated money to some party which has not come to the power, tomorrow I should not be victimized. For that reason, that secrecy aspect, even I should not be victimized, means Supreme Court should come out in a very transparent way, wherein it should clearly state to the government as well as Election Commission of India, including Income Tax Department, that whoever is willing or wishing to contribute for the transparency and accountability towards free and fair election, to uphold basic structure of the Constitution, no individual should be victimized. That should be a blanket law. Parliament should think and pause. At least political parties should come together. Let that be transparent as an individual if I am supporting. But I should not be victimized for just supporting one party. That is my choice. That is how I elect. When I go and vote is also in a secret ballot. When you count, that is also not known. But these nefarious activities some are trying to reveal. But my vote is also in secrecy. At the same time, the fundamental aspect is even through individuals. If you are asking for some guarantees, but even in the guise of individuals, these drug peddlers or terrorist organizations or black money perpetuators may also enter. That is also the reason why I was asking there should be a blanket check wherein the individual himself being a constitutional authority and a voter should be given that leeway wherein no government should question their purpose or donation to any political party. Am I right, sir?
Correct.
That never become a case of a discussion as an individual if I am supporting party. Parties or party in power, or for that matter, Election Commission of India, for that matter, how we see parties try to control income tax and enforcement directorates. They should never ever question me. And that too, that money should be legal and accountable. What do you say, sir? It should have been a tax money.
Correct.
It should be a white money.
Yes, it should be white money. It should go only through the banks.
Yes.
Those aspects are clear.
Yeah.
What the intention of the Supreme Court with respect to this electoral bond scheme is not questioned. But the judgment where they have put the right to informational privacy of a voter above the right to privacy of an ordinary citizen, that is objectionable. And that cannot be held as constitutional. What the Supreme Court has done is a great disservice to the ordinary citizen's privacy, right to privacy.
But
My
here
objection to this entire judgment is only that.
that is the point. But here also, in the guise of individuals, we may see these black marketeers, how they try to control the market. They may enter, drug peddlers may enter, but there should be some mechanism to check that it is the same individual. Out of his choice, he is donating legal money. How should we check that?
Excuse me, Dr. Reddy. Here I will make a small distinction. Now, when I make money, contribute money as an individual, I do it only through a bank where my KYC norms are known to the bank. My objection is making a disclosure of I have contributed to the party to any person who is applying for it under the Right to Information Act.
Yeah, that's it.
That is my objection.
Yeah. KYC is
Because
known, but banks also. But what is the guarantee?
It is immaterial. No, excuse me. Excuse me, Dr. Reddy.
Yeah, please go ahead.
See, if Dr. Reddy contributes 1 lakh to a XYZ party, now how does that information affect me as a voter? Why should I know how much Dr. Reddy has contributed? What I say is, I am drawing a distinction.
Yes.
Now, if a black marketer or if a tax evader like Vijay Mallya or Nirav Modi is contributing 10 lakhs to XYZ party in his personal name. Now, these details are known to the bank and the bank has to forward it to the income tax department or to the whichever statutory body is responsible for this, and they have to take action. I don't have to know who is contributing what to whom. As a voter, I don't have any business to know how much Dr. Reddy has contributed, how much Mr. Ramsamy has contributed, how much Mr. Kupasamy has contributed. It is immaterial. But I have to know how much Kingfisher has contributed, how much Reliance has contributed, how much Adani has contributed. Yes, that I have to know because they are doing it as a corporate house. And tomorrow the government can make policies which will favor the company which has contributed the maximum to it.
Yes.
To my loss.
Yes. Even in the individual case, if some black marketers, drug peddlers, through some individuals, if they are funding, even in spite of KYC, there should be norms in such a way. Again, they should not go to the party in power to judiciously use their power and victimize there should be an independent body. Election Commission of India, that is the reason why we want that to be very, very independent. As we are expecting Supreme Court, the justice system, judicial system. Similar way, Election Commission of India, unfortunately now, Prime Minister and then his own cabinet, subordinate cabinet minister and opposition leader, which we have already discussed, how it is going to ruin free and fair election. It will defeat basic structure of the constitution. Supreme Court, I think, still sitting on that. Supreme Court should have come out clearly and very early. Otherwise, if it doesn't interfere, it is just striking of electoral bonds without going to the basic essence of appointment of Election Commission of India, which should be functioning independently, which is supposed to conduct elections. And if that body becomes a government body or for subordinate to the party in power on that day, then it will never, democracy can never survive. That is the biggest danger we are going to face. So that is the reason why we expect Supreme Court to judiciously, immediately take the trial of appointment of election commissioners by government now. Government has no role. Maybe this party in power, tomorrow some other party, but this will be a bad precedent for people participatory constitutional democracy. And even in this case, while welcoming, in every show we were demanding Supreme Court, what happened to electoral bonds? Why Supreme Court is still sitting on that? A judicial decision made to see that there is a free and fair election and democracy is the one which should survive, and that too, it should be a people participatory constitutional democracy. The courts have to take the call. It should be very early because the delay may create so many problems as it is doing now in this case too. Any other points, sir, which you are willing to add?
Yes. See, as far as the Supreme Court judgment is concerned, I would have been happy if the Supreme Court had read down the electoral bond scheme and suggested whatever changes it wanted to do that without affecting the right of privacy of a citizen to contribute to a political party, the right to political affiliation of a citizen. That should not have been breached. It has been breached now. It would have been better if the Supreme Court had read down the electoral bond scheme and suggested the necessary changes. Portions of the act could have been declared ultra vires, but the major portion of it with respect to right to privacy of a citizen, that should not have been touched.
Yeah.
This is where the Supreme Court has made a mistake. I hope it reviews the judgment and makes the necessary changes. Muted. Your voice is muted, Dr. Reddy. Your voice is muted.